I'm Susan Tierney. This is Scott Horne with the Owner Finance Network, and this is another episode of Ask the Attorney. So, Scott, we're going to talk about owner finance transactions, specifically the subject to, okay? So, I got a contract signed. I bought the house subject to. Now what? What do I do? Where do I go?
Well, Susan, first off, you've negotiated your deal, right? So obviously you've got to get a contract signed between you and your seller, and you need to incorporate appropriate disclosures between you and your seller as well.
Okay.
Now, you may have those from other various sources out there, or you may wish to contact us here at the Owner Finance Network, and we can assist you in getting those completed between you and your seller in that instance. So you start with getting a proper contract package. Get the disclosures executed and making certain that you and your seller are on the same page and you have explained to them what the issues are along the way when you're buying a home subject to the existing debt, leaving that debt in place, that seller is going to have continuing liability, and how the due on sale clause that's in the mortgage may affect that seller.
Okay, so I just send you my contract? I mean, what's the flow?
Well, got it. So, once you are there, you, of course, have got to select your closing agent, right? Now, a closing agent may be a title company. It may be a law firm.
Okay.
Everybody's a little bit different. Some people want title insurance on every single deal. And by the way, in various states, that might be a very wise thing to do. Here in Texas, if you understand liens and how they affect homestead properties, since about 98% of the homes that are bought are owner-occupied, you may not necessarily need title insurance. You also determine how risk-averse you are. Some people are very risk-averse, some not so much. Do they want to pay that extra money for a title policy or not if they really don't need it? What's their actual risk? Remember, when we're buying a home subject to, we're not liable on the underlying debt. We're liable for the money out of pocket we either paid the seller that we used to bring the loan current, or maybe if there are repairs being made, maybe for that amount. So what's the amount of my legitimate risk, and do I need it or not? And so here in Texas, oftentimes we don't use title insurance, but we always do a title search or an abstract of title. In other states, based upon their laws, they may wish to do so. So it starts with determining who's your closing agent going to be. Because remember, a title company cannot close your transaction unless title insurance is being issued.
Okay, and so if they don't want or need title insurance, then they go to an attorney.
They're going to go to an attorney and they're going to close this in a law firm.
Okay.
Now, unfortunately, so many attorneys do not practice this type of a business, or they'll draft just up your basic documents you need and they exclude all the disclosures and the explanation processes. Now, at Horne & Associates PC, which is our law firm here in the Dallas-Fort Worth area, we try to explain to both the seller and buyer the entire transaction. We don't represent them as an attorney, but we do try to walk them through the process and procedures so they have a clear understanding along the way.
Okay. So they just get you they start by giving you the contract. If they're coming to a law firm, they give you the contract. You give them a form that says, here's everything I need. Once they get you everything, how long does it take till you go to closing?
Sure. Well, let's just back up one moment, okay? So let's assume that you're the investor and you've gotten a contract. You're going to need to get basic information from that seller. You need a copy of the most current mortgage statement. If they're behind in payments and maybe in a pre-foreclosure mode, maybe we need copies of that information up from the law firm. We should get a copy of their existing note and deed of trust if available. And as the investor, you should get a copy of their insurance policy because you'll need that. Now, as soon as they have that contract, if they'll get us, for instance, the current mortgage statement, if they've gotten a reinstatement amount in a pre-foreclosure mechanism, get us that amount as well, we can get a disclosure package prepared and sent to them within 1 day. So they can get that executed very quickly. Once they get that executed, based upon the time frames that both the seller and the buyer have negotiated, closing in 1 day, closing in a week, closing in a month, you know, if it's a pre-foreclosure, Susan, sometimes we get deals and we close them 1 day before the foreclosure auction in order to stop the foreclosure. I prefer to have 10 to 14 days minimum because we want to give our seller complete opportunity to review the contract, review the disclosures, seek outside counsel of any type they should wish, so they get clearly informed before they sell their home in this fashion.
Okay.
So I always put things in a simple step-by-step fashion out there, but the first start, contract, get information from the seller, get the disclosure signed, get it to your closing agent so they can get the title searches or title policy moving forward quickly, and then move to closing at a time frame that both the buyer and seller have agreed to.
Okay, and in that process, do they need to include an RMLO?
Well, if the investor is buying a home subject to the existing debt, simple answer is no. It's a commercial transaction, not required. But a seller may want some basic financial information on the investor buying the home. Is it okay to fill out a 1003 application or some type of an application? Absolutely. Is it okay to give that seller your tax returns? Absolutely. Maybe a verification of rent or a verification of a mortgage, maybe a verification of employment form. What are they asked for?
The seller's going to ask this?
Absolutely.
I've never
they
had
could.
a seller ask me that.
Well, you know, they usually don't because they usually don't have an attorney involved. But if I'm the seller, I want to know who my buyer is. And I want to know if they have the ability to make the payment on my house.
Got it. Got it. Okay, so now let's talk about, you've bought the sub-2 property and you want to do a wraparound mortgage.
Okay.
Okay. What is that? That's now a whole new transaction, right?
It is.
It's another closing. You can't combine the two, or can you?
No, you can't.
Okay.
We can close them back to back, but you
Okay.
can't, but they're not the same thing.
Okay. So then what's the process of that? How do you get that started? Where do I go? What do I do?
Well, obviously, let's assume you've already found your buyer and you've already pre-negotiated the terms of your transaction, right?
Right.
Okay, pretty simple. So we need to go to contract. Now, we always recommend here at the OFN to use a state promulgated contract form
Yes.
whenever possible. Some people don't like doing that. We do. We have disclosures that we like to utilize also and recommend to be used when you're selling a home with a wraparound mortgage between the seller and the buyer. So if that's the case, let's get those executed because our back-end buyer has the same issues we have if we bought that home subject to. Because there's an existing mortgage, there's a due on sale clause. We want to make sure those things are properly disclosed. We want to get the buyer and seller on the same page on things such as, who am I making my payment to? Do I pay the seller direct? Do I pay the underlying mortgage company direct? Or am I going to use a third-party loan servicer? Got it. You know, what about insurance? We want to make sure we get proper insurance put in place. And our disclosures walk buyers and sellers through those items that are needed in a real estate sales transaction like this and a mortgage, because there is no mortgage company involved. Remember, our seller is not only the seller, they're the mortgage company. They're the lender and they're the underwriter.
Right.
So somebody has to implement all these issues and make certain that the buyer understands what they need to do.
Okay. And that's where the RMLO comes in, right? On the back end?
Well, the RMLO comes into play as soon as we get our contract signed for our buyer, we get our disclosures executed, and we get our earnest money. I like to send the buyer immediately to an RMLO. This is a consumer transaction where in most states it's going to be required automatically. But that RMLO ensures that the borrower has the ability to make the monthly payments on this mortgage. And that's one of these Dodd-Frank requirements we have to think about when we're selling our home using owner financing to a borrower. We don't want to sell a buyer a property they can't afford. We want to do that. Now, what the RMLO is going to do, though, is they are going to meet with that borrower, and they're going to get all their financial information. They're going to get a standard application. They're going to ask for tax returns. They're going to ask for verifications of rent, verification of employment, maybe bank statements, whatever they need to put together a proper package to ensure that they have a reasonable debt to income ratio, so they can give the investor seller that package to look at and review, so that the investor seller has the ability to properly consider and verify that financial information to approve that borrower.
Okay. And how long does that process usually take?
Well, it should take 10 days or less. You know, it depends on how fast that borrower provides information to the RMLO.
Okay.
If it's quick, they can start it in as little as a day, and usually it's about a 7-day process, and I believe the total time frame from start to finish is 10 days.
Okay. So then after the RMLO will send me the information, and I'm the lender, so I get to decide. Then what do I do with all those documents? Do I bring them to closing? Do they go to the law firm? Or is it just
No.
something I keep in my safe?
Good question. Well, the loan processing package that the RMLO provides you as the investor is for your files. The closing agent doesn't need that at all.
Okay.
Because the seller is the sole decision maker. So many investors think that the RMLO is there to make decisions on behalf of the seller.
Right.
They're not licensed to do that. Their license doesn't protect them or cover them to make those calls. I can only imagine what would happen if someone thinks that an RMLO approved the buyer defaults, and it costs that seller tens of thousands of dollars in lost payments. Is that seller going to go to that RMLO and sue them for damages for approving this buyer maybe inappropriately?
Right.
And so I always recommend that RMLO should never approve a borrower. That is the risk of the seller, the investor, whoever it might be in that instance, to be that sole decision maker
Right.
along the way.
Okay. And also you want to keep those documents in a safe place, because years down the road, if you want to sell that mortgage, they will require to see your RMLO package,
Well,
right?
it certainly is beneficial to have that available, right? So your processing documents are there to validate that at the time of sale, you made a quality-informed decision that your borrower at that time had the ability to afford the home.
Right.
That you made a good decision. In other words, they didn't have an 80% debt-to-income ratio, and you sold them the house just to collect their down payment. And you know, Susan, unfortunately in the real world, that does
That
happen.
happens.
And then you keep that package as part of your collateral package permanently, because you never know, a year from now, 5 years from now, 15 years from now, what if you wanted to liquidate that asset and get out? Well, you could sell that note into the secondary marketplace, as we call it, and get paid for it. Maybe you've collected all your money up front you were happy with. Now you're getting this windfall on the back end. A lot of people do that out there. So that simply helps to support your position, and it helps to maximize your profit.
Okay, great. That's great information. Thank you. And thanks for joining us at Ask the Attorney. We will see you in the next episode.